Privilege of filing a petition under the Indian Divorce Act. The district, that was sometime in 1982, if my memory serves right, I was quite young at the bar. The district judge said, you file, it's an expertise. He said, file an affidavit, I'll grant, what is there? Why should you want the lady to depose? You see, as a young lawyer, I said, no sir. Book it in the chamber. I said, Your Honor, he has to give the evidence in court, is required. Nothing to it. So, what can I say as a 5-year-old counsel? Order was reserved. 2 days after, what we call here Rasura, Jamadar and certain, I don't know what they call in Uttar Pradesh. Jamadar. So he came, such district is searching for me. I thought to myself, possibly he has read the section and everything. He said, no, she has to depose. But then we went. It was taken in camera. I had the assisting counsel, junior was there with me also at the time. Both of us there. Then while the lady stood to depose, she said, ask your junior to go. I said, you please leave. I put leading questions. She only said yes. The judge wrote. Divorce was granted and again confirmed by the, there is a preliminary decree confirmed by the 3-judge bench of the High Court. Look at the onerous conditions imposed therein. On what ground you can get divorce. The following Delhi and Kerala also, the Delhi High Court declared those provisions to be ultra-virus. I think now the same is not there. Then the question arose beautifully again, that was in 2007. The women were not allowed to, they cannot remain in charge of the cabin in a flight. Lot of a circular came that was challenged. A plea was advanced by the administration on the basis of Nadish Mirza and another judgment of the Supreme Court that it's possible. They can't do it. Nadish Mirza says so. Delhi High Court, by an elaborate judgment, analyzing the ratio of those two judgments, came to say, it doesn't say so. It only upheld a particular facet of a particular rule. Now, you can't make this discrimination unless they are unwilling to do so, on the ground that they cannot be a part of the cabin crew. Because the tag was only a man. Because that you can't make that difference now. The tag is man and tag is woman. Then the question arose with regard to armed services. Armed services, you said, they did not want any woman to be in the what is called the short service commission. That you can work as short service commission as a lady, as a woman, but you can't become a permanent commission. Delhi High Court in 2009 said, no, they can. You have to do it. Unless you find that she is unfit. But you can't ipso facto say she is a woman and therefore her rights are nullified or cannot be looked into. You see, then the question arose about the very interesting thing. Another legislation came that a lady, no woman in a hospital industry, like in a restaurant, she can't serve liquor. I mean, she may not be a bartender. That was challenged. Lot of arguments were canvassed. Why? The court asked. That was the question posed. That eventually they said the rule or the legislation, the rule is bad. It affects the affirmative concept of the Constitution and creates discrimination. But they say, if a lady says she has no objection, she has to be given the duty or considered for that. Purpose of saying is that the held right to work is an inalienable right, and you cannot impose the condition solely on the ground of sex. Now, I would like to say another aspect. There was a blind student who applied to study in medical science. He was not selected. After notice was issued, that's from Madhya Pradesh. Again I will go back there. The Madhya Pradesh High Court said the 40% vision, what my lord just now read the schematic things, partial blindness. He was not blind. Actually, it's a vision orientation lapse, as they call it in medical terminology. What's the difficulty in giving him a seat if reserved so? He comes in the reserved category under the 95 Act. The High Court said, you better give him a seat in the administration. You can't deny him that benefit. Go. I'm trying to put that in here also. I do not know how many of you have interacted, I use the word interact, with the spastic children. I presume all of you must have done it, because I have had the privilege to interact with spastic children on more than 3 occasions. I was really surprised. They invited me, I was a judge, a month-old judge. I was a guest. Courtesy the organizers, I'm obliged to them, that they had to do dance dramas. The spastic children who can't really communicate, are not articulate, don't understand how do the dance drama. Believe it, they perform for 2.5 hours, at various levels. Song and music, guided their steps, movements. Then I asked the organizers, in fact I went to a neurologist to ask how they can do it if they are so spastic, so disabled. He said there are certain neurons which immediately respond to the sound and the music, and that's inexplicable. They really acted, they really also murmured the lips when the song was going on. Like you have the films are doing it. How? It's still inexplicable. In fact, I suggested to one of the organizers, why don't you try to give them some music treatment? Possible there can be some development in the brain. I don't know. A question which has to be addressed. 2. My lord gave the example of Ravindra Jain. Now the World Cup is quite ahead. When I was in college, we were really fans of Kotauri in a different way. We were just talking a name for nothing else on a question of ability. After he lost his eye in an accident, totally, everyone proclaimed a man with one eye can never play cricket. It's impossible. He, with his dedication, determination, and I must say, instinctual ability, went to bat and scored 221. That's the highest score by that time by him. And thereafter he played many tests and captain. And if my lord recalls, in Calcutta when Clive team came, he was a captain. He was recalled and he scored 36 after being injured and he won the match. Gochia and Bradley from England were compared because of excellent captains, strategic captains. So sometimes, like Hopkins, you see, they say for suffering from motor neuron disease, you are gone. You may not live long. But look, the man has come with again a banned book, I would say. God doesn't exist. Whether you agree or not is another matter. Scientifically, it's a well-written book. I had the privilege to go through it in a different way. So, now, I think I'm within my time. I must close with one line, that human perception with regard to our previous religious mandates, scriptures, and attitudes have to change. When I say ours, I do not include the people who are here, but definitely they are much more wiser than I, all of us have changed. But only our changing would not do. I am not a summarizer, I can't afford to be. And Only thing I say, we really have to make some effort to sensitize people. You see, I'll just end with this. A man came to me. I have 2 daughters. May I have your attention, please? Focus on me. I have 2 daughters. Someone came, I'm sorry, it's in the right order. Someone came to me in the early 90s and said that you must have a son. I said, why the hell should I have a son? What for? That if you don't have a son, the Shastras say you are likely to go to hell, not hell. So I said, yes, right, I know that. But if you tell a lie, you go to hell. If you drink, you go to hell. If you take non-veg, you'll go to hell. If you abuse your neighbor, you go to hell. And I've done all that in my different way. So that I have already reserved for 40 years or 50 years there. So another 10 years will not make a lot of difference. The purpose is the obsessive with regard to the male child. Because the Shastras say, Putra te kriyate bharya. I'll tell you in English that you have to marry because of a son. Whatever it is. But here the meaning has to be different in 21st century. Of course, in last century also. Putra doesn't mean a son. It means a santan which includes a daughter, a woman, a lady, the feminine charm, the feminine dignity. That is why possibly the E.M. Foster wrote, a man must be masculine, need not be brutal. A woman must be feminine, but should not be effeminate. Therefore, the gender bias has to be totally ostracized, guillotined, annulled in entirety. And I must say, thank you for being kind to me to listen to me. Thank you.
I was just wondering, the next, in fact, speaker would be Lord Lester. It's all right. He will be speaking on the UK Court of Marriage Act. Yes.
Thank you very much. Actually, Mr. Chairman, I was thinking that I should not speak, simply because I believe that even judges may be protected against inhuman treatment or punishment. And you've been here now for 2 days, and it's 4 o'clock, and it's the weekend. And I actually asked one of the organisers quite seriously whether you would prefer it if I didn't speak. And if you had a secret ballot, I'm sure you would say that I shouldn't speak. But I've been told that I must speak. So I shall.
At least for a little while.
I'm not under your authority in the general sense. I could go on for an hour, but I shall not go on for more than half. Okay, I'm going to talk about something which concerns India and Pakistan and Bangladesh, and in fact the whole world, which is the serious social evil which consists of forcing children and young adults to marry against their will. It gives rise to gross abuses of human rights, especially affecting children and young people of either sex, and in the British context, especially within our British Asian communities and elsewhere. It involves inhuman and degrading treatment and punishment of those who resist coercion, even their murder. It's a form of domestic violence, and there's a direct link between forced marriage and so-called honour killings. Forced marriage is, of course, an oxymoron. It is condemned across and within all communities, including their more religious and traditional sections. It's a form of sexual enslavement, sometimes amounting to domestic slavery. Dowry is often paid, and women are bought and sold in the process of being forced into a so-called marriage. Forced marriage affects children, teenagers, and adults from all races and religions, including Christians, Hindus, Jews, Muslims, and Sikhs. And it is not solely an issue affecting Asian communities. The Forced Marriage Civil Protection Act 2007 adopts what the government described in the context of human trafficking as a victim-centered human rights approach. It empowers women and children, enhancing the protection given by existing law, and it seeks to help the Forced Marriage Unit, which I'll describe briefly, and other agencies and NGOs to develop and implement training to develop victim support networks and secure compliance with the unit's guidelines. I decided to do this bill in 2006 when it had been decided that we should not make forced marriage a crime because there was plenty of criminal law already on murder, kidnapping, abduction, rape, and so on. It seemed to me that there must be some other way forward than criminal law. And so I set about trying to fashion a remedy. But of course I am white and male, and I have none of the brains that Mr. Justice Deepak Misra referred to. My brain is that of a social engineer with a fanatical zeal, but I'm not sure whether I'm instinctive, intelligent, intellectual, or any of those other matters, but I'm certainly practical. And I realized that a white man is not best placed to deal with the problem of forced marriage. So I went to a wonderful body called the Southall Black Sisters. They do not live in Southall, they are not black, and they're not sisters. And they made me, in fact, I am now a Southall Black Sister myself, at their suggestion. And we sat down together, and what I learned from them, and what I learned from going to Asian refugees in Britain, and what I learned from the academic study as well, was that criminal law is not a sensible way of dealing with the problem, but family law is. And that what you need to do is to find remedies that give civil protection, that are not punitive, that do not take place in public, and that do not involve permanently dishonoring the family, so that the victim will not ever be able to go back to the family. And so we invented an entirely new legislative approach, which I do not believe exists anywhere else in the world yet, although I very much hope that it will exist here and in Bangladesh and in Pakistan, among other places, because the problems it's dealing with cannot be solved in any one country. They are truly transnational. I probably don't need to describe to you the kind of problems we're talking about if you know anything, as you will do, about the real world. But one of the examples that was brought home to me when I was devising the bill was a book by a Sikh, Jaslinda Sangera, who lived in Derby, which is a small town in the Midlands. She was born in a Sikh family in Derby, one of 7 sisters, all coerced into marrying Sikh men living in the Punjab. She was the only one who escaped by running away and being treated as dead by her parents and siblings for bringing shame on them in the eyes of the close-knit community. Jasminda described her struggle to survive the brutality of family and community coercion. Her escape, aged barely 16, was into poverty and destitution. One of her sisters committed suicide, being sent back to a brutal husband, and she then worked on behalf of women affected by honour-based violence, where the suicide rate among Asian women in Britain is 3 times the national average. Those who stand up to family oppression receive real threats to kill. if they run away, they have to live in hiding. Jasvinder's story is a vivid, honest, and deeply moving narrative of despair. And in her book, she noted how our public authorities turned a blind eye to the problem in the name of cultural diversity. And I discovered to my shock when I was in Derbyshire that, for example, the local education authority was refusing to put up a poster with a helpline phone number where young girls or boys, mainly girls, but sometimes boys, were being coerced into marrying, in inverted commas, against their will. The local authority decided not to do this because they were frightened of offending the elders of the local Sikh community. So the puzzle was, and of course what I'm describing, you could describe here, or in Bangladesh, or in Pakistan, or in Turkey, or in Germany, anywhere you like, because it is a universal problem. The question then is what you do about it. So what we did was to create a statute which allows not only the victim, not only someone authorized by the victim, not only an NGO, not only a police officer, but anybody to approach the court ex parte and to seek a forced marriage protection order from the family court in private. In private, and often not showing the evidence at that stage to the respondent to the notice, but only looking at it themselves. That was in itself quite a radical step forward to allow a very generous third-party intervention, because very often the victim is not able, even those who are with her, are able to move the court. And then we devised a procedure where the respondent was served and allowed to appear, all in private, but the product, the outcome of the process would be something like an injunction, a forced marriage protection order that would apply not only to conduct in Britain, but conduct in any other part of the world. So if the coercion begins in England and then moves here, then the coercion here would also be forbidden under the forced marriage protection order. It is a transnational order. Now, another important part of the scheme is that the forced marriage unit, which is run by the Foreign Office and the Home Office in Britain, and has offices here and in Bangladesh and in Pakistan and elsewhere, they have given guidance, extraordinarily valuable and detailed guidance, multi-agency practice guidelines, all on the internet, as to how to tackle the problem. And for anyone who's really interested, and you've got too much paper already, so I haven't had any of this copied, it's on the internet. But for anyone really interested, you would find the guidance, which is very full of enormous practical value. In Pakistan, one of our senior former family judges, Baroness Butler Sloss, she's now with me in the House of Lords, she had the bright idea of sitting down with the Chief Justice, I think it was, of Pakistan, and entering into a judicial protocol for mutual assistance. So, let's say a young girl, Shahid, she's taken on a holiday, Islamabad, she thinks it's a holiday, she lives with a man, she doesn't want to marry the man's going to rape her, get her pregnant, then come in free of immigration control on the basis that they've got a child, all of that. They lock her up because she won't obey, there she is. Liz Butler Sloss entered into a protocol with this admirable Pakistani judge for mutual assistance to be given judge to judge. So that if an English judge makes a forced marriage protection order and says it's to apply everywhere, there's the order, and the idea would be that the Pakistani judge looks at it and does something about it. I mentioned this with great pleasure to my friend Azma Jahangir, who was a famous human rights advocate in Lahore. And she surprised me by saying, don't you realize it's unlawful and it's been held to be so by the Pakistani courts? These judges have no authority to be entering into a protocol of that time without legal authority. I didn't know that, and if it's correct, it probably is. It shows the crying need for legislation in Pakistan to authorize mutual assistance between the courts of Pakistan and the courts of the United Kingdom in tackling this problem. But of course the same is true in India. As you will know from your history, Mahatma Gandhi in 1929 in the Saga law legislated, or rather persuaded the authorities to legislate to deal with the problem of child marriage. And as you also know, 2 or 3 years ago, that law was brought up to date, dealing with child marriage and dowry here. As you also know, there's the Domestic Violence Act, which doesn't deal with this problem, but that also has been recently enacted. But there is a complete gap in your legislation to match precisely what I'm talking about here. Some of you will no doubt tell me there are constitutional provisions, there's the Prohibition of Child Marriage Act is what I was referring to. These are all important measures, but none of them is of direct practical value in the way that is needed. So, and the same is true in Bangladesh. I mean, the abuses are different in each country and beyond Bangladesh. Within the European, within the Council of Europe, there is now, which is 47 countries, so it's almost a third of the world. Within the Council of Europe, work is at this very moment progressing on a new convention on preventing and combating violence against women and domestic violence. It is more criminal in nature than I would like, but that's because the Continentals tend to rush for criminal statutes to solve problems without having as much civil protection. There is also, just for completeness, an opinion of the group of experts on trafficking in human beings of the European Commission, where they focus on a recent judgment of Judge Palm's court in an important case called Rantsev and against Cyprus and Russia, which decided that there are positive obligations on the state to protect against these kinds of situations, positive obligations. And I have no doubt that India and Pakistan and Bangladesh, like any other parties to the international human rights conventions, has positive obligations, which you can probably get derived in any case from the articles of your constitution that have been so clearly expressed by you, Mr. Chairman. Now, you are not, although you are lawmakers, you're not supposed to be under your constitution in a technical sense, but you are a very influential group of people. The most influential group I think I have ever addressed on these issues, apart from my parliament. And what I do suggest is that it would be very much in the public interest if the judiciary of India could take the lead in bringing home to the political branches of government the need for specific measures to enable this problem to be tackled. The civil part, the Forced Marriage Act has been a remarkable, quite remarkable success. It's only been in force since 2007. We now have had 80 forced marriage protection orders in the very first year of its operation, the very first year. And there are 13 designated county courts. We do it at the county court level to make it user-friendly. We've had judicial training something we do all the time, on the Act. Just as we spent £6 million training every judge and court and tribunal on the Human Rights Act for the 2 years before it came into force, so we have spent a lot of money educating judges, using family court judges to educate them on the need to be sensitive to these harrowing and terrible cases. Terrible cases because often these girls or boys have got to be put in special care with protection, lest they are seized by bounty hunters and brought back and subjected to horrible things. And the guidance for the statutory authorities is now statutory guidance. And forced marriage, even though we are running out of money in our civil justice system, public funding is specially provided. Despite the savage cuts in legal aid, it is still being provided for forced marriage because the authorities realize that this must have a very, very high priority. There is a problem, a different problem in the fact that they're cutting the budgets of local government in a fairly serious way. That will have some impact and it will affect the refuges where these girls can hide and be looked after as well. So I'm not suggesting that everything is at all perfect, but I do believe that what we've done is a model of what should happen. And when the Minister here, I forget her name, was introducing the Prohibition of Child Marriage Bill, I remember her saying that she hoped that it would also tackle the problem of forced marriages. Well, it does a bit, but I don't think it deals with the heart of the problem in the way that it's needed. So, I think I've taken about 20 minutes max, and I could go on much longer. I don't think I need to, but what I'm doing as an unashamed campaigner is to enlist all of you in my campaign to try to reduce this problem by having cooperation across the subcontinent and with us, to whom you privilege us by sending 800 or 900, no more, 2.5 million of non-Muslims and almost 1 million non-Muslim British Asians now are equal citizens in Britain, but bringing with them these kinds of problems which need, I think, really urgent attention. Thank you very much.
Thank you, Lord Lester. I would just like to tell you one thing, and that is, although we do not have, firstly, these understandings in place regarding the laws or the judgments of one country applying to another or to India itself. Recently in the past we've had situations where we had to deal with custody matters where by judicial pronouncements what we have done is we have gone by the concept of Committee of Nations and we have given due respect to the orders which have been passed outside. And there has been cases where people within the jurisdiction of the High Court of Justice in London, the Family Division in London, in the High Court, their orders have been sought to be implemented by sending the people back from here to face the pending proceedings there. We've done it. But it has been done not on the reciprocal level, but on the basis of, as I said, the Committee of Nations. Now our next speaker is Justice Roshan Dalby from Bombay, and she will be speaking on equality and non-discrimination decisions from the High Court, very much, and I think the same lines as Justice Deepak Mishra, Chief Justice? No? Very well, fair enough. I mean, you are free to do as you choose.
I will do what is my duty. I realize most of the time, as I realized this time, that somehow I'm
if you want to
presentation
discuss
of 1 hour on this.
If you want to discuss things about juvenile justice, child trafficking, women trafficking, this by itself will need 1 or 2 days of deliberations. We have many things in place. Nothing seems to be, see, unless, as you said, unless you sensitize people. Anyway, our next speaker will be Justice Ashok Bhushan from Devabad High Court.
Justice Kavi, the chairman of this session.
Otherwise, the legal parameters of 21 or even section 151.
We used to 21, but the exact legal parameters.
And how do people know this? You know, I mean, there's a young girl trapped God knows where. Is all this well known to the public? Is there a